Suaves.
छी 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 अगर अब आपने कुछ बोला
Hello. Can you tell me in which time will you start? Hello.
Good morning, everyone. Today's session would be taken up by Ms. Juhi, who is an advocate by profession and has a vast experience of more than 7 years in crime against women, public interest litigation, corporate litigation, civil litigation, contract management, intellectual property rights, corporate governance, restructuring, compliance, finance, marketing, and branding. She is also trustee of Vidya Vijay Foundation and leading the project POSH. She has delved deeper into creating awareness and educating people about prevention of sexual harassment of women at workplace, as well as empowering women and men with regard to their rights at their workplaces. She has taken more than 150 training sessions across all sectors of society, and she has trained more than 2,000 people, building their capacity in educating others about POSH and empowering them towards the betterment of society. She is accredited for her excellent communication skills, which encompasses public speaking and liaising with top management of big corporate houses. She is a regular speaker on various capacity building, self-awareness, and legal topics at various multinational companies and professional institutes. She is also a member of committees across big corporate houses, including the Internal Complaints Committee, formed under Prevention of Sexual Harassment of Women at Workplaces. Now, I would like to invite Ms. Juhi to continue with today's session.
Good morning, everyone. I would like to thank Nitya sir, first of all, for giving us all this platform to share this knowledge and on different topics on every second Saturday and the fourth Saturday of the month, so that we can enhance our knowledge in different fields and use that in our practices as well as in individual life as well. So this session, today's topic is very important, and this session is very important for each and everyone, whether we are individual or the practicing advocates, CS, and everyone, because this is a topic which is emerging about the every problem we are facing at the workplaces relating to the sexual harassment. So we will see the law relating to the sexual harassment we are having and the measures we can take to redress the grievances of the sexual harassment and all the procedure, recent developments, recent case laws, and all such things we will discuss today. And apart from that, in this webinar today, half an hour we will have for the half part of the session, so that we can discuss what are the important definitions, what is a sexual harassment, what is important topics in this which we should all know what kind of behaviors we should do, we should not do, and that may amounts to sexual harassment. So we have to consider all that in the first part. Then I'll take 5 to 10 minutes of the question answer session. Then redressal part we will cover up in the second half of the session. So let's start with it. The slide is visible to all of you. I would request each and every one of you, as when I ask any question, please answer to that by unmuting your mouth mics.
Yes, yes, ma'am. This
Okay.
is visible. Please continue.
Okay, thank you. So now we'll discuss, first of all, the laws governing the sexual harassment. If at any workplace, any kind of sexual harassment happens with a woman, there is already a law prior to this act, which we are discussing today, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 and rules made thereunder. Apart from this, prior to this 2013, there was already IPC, there was already Industrial Employment Standing Orders Act 1946, which was governing the sexual harassment incidents at the workplaces. Because 354 we are having in IPC, 376 and 509. This is all about outraging the modesty, rape cases, and all such things. They are covered under the IPC. But the procedure there was very harassing and sometimes embarrassing for a woman. So most of the women, despite facing the sexual harassment, were not having the guts to go to the police station and complain about it. So that is the reason why the legislature, why the Supreme Court first time felt the need that there should be a sexual harassment laws which is more helpful for a woman and which is inside the organization only. If she wants to complain, that should be inside the organization, so that it will not be harassing for a woman, it will not be embarrassing for a woman to reach out to the ICC. So that is why this act has been framed. So we will discuss, first of all, evolution of this POSH Act. In short, this act is being called POSH Act so that it can be easily protect the women at workplaces. So why there was a need? First time the need was felt when this case has happened in 1992. There is a social worker in the Rajasthan. She was working for the state government of the Rajasthan for the campaign which is preventing the child marriages in the state of Rajasthan, because in previous scenarios we are having the trend of having the child marriages in our society. So now also some in some places of villages and somewhere it is prevalent, but at that time this Bhavri Devi was working for the campaign of state of Rajasthan which is preventing the child marriage. One Gujjar family was marrying their 9 months old baby girl to a some man. That is why this Bhavri Devi has reached out with the police officers at that place and she stopped the marriage. So in grudges and due to the anger, those 5 men of that Gujjar family raped the Bhavri Devi in the fields of Rajasthan when she was working in her fields before her husband only. So her husband was also brutally beaten up. And after that, when she reached to the police station, nobody has lodged her FIR properly. Proper medical examination was not done. That is what the reason they all got acquittal, because there was lack of evidences. The court has not found any evidences properly, so they have given an acquittal to all the accused person. After that, there was a lot of anger in the women activists and the NGOs who was working for the social empowerment of the women and for their rights. So they all, one of those NGO, the Vishakha was an NGO. One of those NGO along with the women activists filed the PIL in the Supreme Court and requested the Supreme Court to frame a guidelines and to make something that what are the workplaces will be covered, and because they have taken a plea that she was working in the fields of Rajasthan, so that is not the workplace, but she is working for the state government campaign and the state includes that entire Rajasthan where she was working, so that will be covered under the workplace. So in this case only the Supreme Court framed the guidelines first of all and requested the center also, the legislature also, to frame a proper guidelines, to frame a proper act so that these problems of sexual harassment women are facing at workplaces and they are feeling unsafe, that can be curbed upon. So after that, these guidelines have been named Vishakha guidelines because the Vishakha NGO has filed the PIL. So these guidelines have been named in that Vishakha guidelines. And the Supreme Court in these guidelines has framed the entire things like what will be the workplace, what will be the measures to be taken to safeguard the women. All such things were there already, but nobody was complying that. Why they were not complying? Because there was no fine provisions, there was no penalties. These are only guidelines to be followed by the workplaces. So nobody was aware about these guidelines also well prior to this act, because nobody is complying, because we are having, being a human being, we are having a tendency that until unless something is not fine, something is not a crime under the law, we are not going to follow that. And that is what the reason nobody was complying that prior to 2013. So the center finally decided to frame an act, and the legislature had formulated this act in the 2013, which is called Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. So the name of the act itself suggesting that what it is for. Basically, it is for first preventing the sexual harassment, then it is specifying the provisions for the employer that you should inform all your employees, you should make them aware that we are prohibiting the sexual harassment in all cases, because we are having the zero tolerance at all the workplaces. So that kind of measures it is providing. And apart from that, redressal measures also this act is providing, that despite taking the preventive measures, if any kind of sexual harassment happens at any workplace, then what is the redressal measures? How to file a complaint, how to do inquiry, how to make a recommendation, and how the employer will take an action against the sexual harassment. All such provisions are prescribed under this act. So this is, we have already discussed, this act is in short called a POSH Act. Now we'll discuss the constitutionality, because as and when the new act is being framed, someone is aggrieved by that or someone is feeling something lacking in that, and they file a question, they file a case in the court that this is not a constitutional law, this is not properly dealing with this issue. So in this case also, the matter has been went to Supreme Court, and this Medha Kotwa Lele and others versus Union of India and others case, this has been decided that this is the proper act which is providing for the protection of women at the workplaces and safeguarding them properly, and this is a full-fledged act which can safeguard the women if properly complied with. So in this case, the Supreme Court decided by the Supreme Court that in 2018, the case arose from a petition filed by a group of women's rights activists, including Medha Kotwal Lele, challenging the constitutionality of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. The Supreme Court rejected the petitioner's argument, holding that the POSH Act was constitutional and that it provided sufficient protection to the women against sexual harassment at workplaces. So in this, the court has properly held the constitutionality of this act, that it is proper constitutional and is providing the sufficient measures to protect the women at the workplaces. Now we'll discuss the entire scenario, the entire things in this act is revolving around the sexual harassment, that what it is actually. So it is very important for all of us to understand what is the meaning of the sexual harassment. Any act, sometimes there is a very thin line between the sexual harassment behaviors and the normal behavior between the two persons. So, and the one thing, this act is for the women only, but sexual harassment at the workplace is prevailing. That can be against a man, or a woman against a woman. So same gender complaints can also be entertained. Same gender harassment can also be there. So we'll understand that what is the actual meaning of the sexual harassment. Any unwelcome act or behavior, either directly or by implication, physical contacts, advances, requests for sexual favors, making sexually colored remarks, showing pornography, and other verbal or physical conduct of a sexual nature. So this is all our sexual harassment. Whether you are saying directly to somebody anything or by implying, if that behavior offends a woman, then that is a sexual harassment. And if any kind of behavior the woman is unwelcome and still you are doing again and again bothering her, that behavior is also a sexual harassment. Making any sexually colored remark, suppose you are saying somebody has having a red lipstick or wearing a red dress, you are saying this red dress is making you more desirable. You are just making a comment, or you are from your side trying to make a comment on her, but that is bothering her, that is unwelcome by her, then that will be sexually colored remark, and that will be amounts to sexual harassment. So you have to be very, very cautious while making any comments, while making any kind of remark on a woman at the workplaces, and showing any kind of sexually pornographical images and keeping it in a laptop, opening in the offices, which is getting uncomfortable for the women around that. That is also a sexual harassment. Asking for any sexual favors directly or by implications, by your behavior, by doing some things regularly on a regular interval. So that can be a sexual harassment. It can be once or a twice or any time, but that is a sexual harassment. It is any conduct that is sexual in nature and unwelcome, imposed, which is not reciprocated by the woman. Means she is not doing the same behavior with you. She is not reciprocating it in a welcoming form, but you are still bothering her. That will be the sexual harassment. Now we can understand by some examples that what kind of sexual expressions we can have at workplaces, which may amount to sexual harassment. Asking someone on a date. If you are asking someone on a date and she is not interested, despite that you are asking again and again, you are bothering her. So that can be sexual harassment. Staring or watching someone. If you are regularly staring someone and which is making her feel uncomfortable, that can also be a sexual harassment. Complimenting someone on their appearances. We have just discussed the red dress example, that you are saying somebody that you are looking more desirable in this red dress, but she's taking it otherwise. Then in that case, that compliment can be turned into a sexual harassment. So be very cautious while making such comments. Having an affair with a colleague. This is the example where you are having an affair with your colleague, but sometimes what happens after this, when the relationship gets sour, in that case there is a things bad things between them, then but despite that the man is trying again and again to approach her and she is getting away from her. In that case, she can file a complaint that he's bothering me again and again and sending me this kind of messages, this kind of what kind of behavior he's doing. She can complain that. So be little bit cautious while having affair with the colleague. So unnecessarily sending flowers or gifts. If she's not welcoming it and you are again and again sending the flowers, making some notes, writing something for her, so that can be a embarrassing thing for her, and that can amount to a sexual harassment. Imposed unreciprocated behavior. You are imposing something on her, but she is not doing the same kind of a giving you the same kind of thing behavior. So that can be a imposed behavior. Leaving notes for someone. We have discussed, if you are writing something, giving something in writing somewhere, that can be read by someone else, which can be embarrassing for her. So such kind of things can also amount to sexual harassment. Flirting, unnecessary flirting, when until unless it is a joke or a something for a fun. In that case, if she is welcoming it, that is okay. If she is not welcoming it, she's straightly said to you that she is not liking it, but again and again you are flirting with her, then that can amount to a sexual harassment. So these are very basic things you have to learn, that something which is unwelcome, she is not welcoming, she is saying that she is not liking you, you don't have to do that kind of behavior at workplaces again and again with the women. Any act of behavior of sexual nature may amount to sexual harassment if it includes, if you are saying someone that if you are giving me sexual favors, I am going to give you a preferential treatment, I'm going to give you this project, I'm going to give you a promotion, such kind of promises if you are making either impliedly or explicit, that can be sexual harassment. Implied or explicit threat of detrimental treatment, this is the opposite case where the you are saying I'm going to give a bad report about you, about your performance. If you are senior position, you are at a senior position and that girl is reporting to you and you are asking a sexual favor from her, that if you are not going to give me this sexual favor, I'm going to give a bad report about you, I'm going to give a like a bad performance report and such things which can stop her promotion, appraisal, or such kind of a thing. In that case, that will amount to a sexual harassment. Implied or explicit threat about her present or future employment status. Suppose the person to whom she is reporting, you are saying that if you are not doing this favor to me, then I'm going to give a bad, I'm going to throw you out from the job, I'm going to ask him to throw you out from the job, to the person she is reporting. So that case, you are saying future employment status, there is a threat to her future employment status. So such can be the sexual harassment incidents. Interference with her work or creating an intimidating or offensive hostile work environment. Suppose once the woman has faced sexual harassment or some kind of that, she's not clear. Sometimes there is a behavior of a man at the workplaces where a woman is not clear that whether he's having the same intent or it was by the accidentally it was done. So sometimes such environment can create a hostile work environment for her. If she faced once the sexual harassment at workplace, she is always at the threat of getting it again. She will be always in the intimidating situation that I can again be facing the same situation again. So the work environment will be very difficult for her to work there and hostile. She will always in the back of mind having the threat of facing that again. So that kind of creating the environment will also amount to sexual harassment. Humiliating treatment likely to affect her health or safety. Humiliating treatment, we have discussed some examples, writing a note, sending flowers, or flirting again and again, or saying something which is humiliating for her. Shouting by the senior on a junior in front of everybody. That is also a humiliating treatment. So if any senior is shouting on a woman before all the employees and all such persons, then that is also a humiliating treatment that may also amount to sexual harassment. So if we are in a senior position, especially the men, if they are at a senior position, they have to be very formal, they have to be very polite to a woman, because that may amount to whatever behavior done in anger or something like that, that can be a sexual harassment, that can be treated as sexual harassment and that woman can complain of that. So be very cautious about that. Now we will discuss some behaviors that may amount to sexual harassment, like obscene gestures. Sometimes the man doesn't say anything, but man or a woman, they don't say anything, but they give some gestures which can amount to sexual harassment. So sexual teasing. Suppose sexually you are teasing somebody again and again, that is also a sexual harassment. Suggestive looks and remarks. Suggestive looks and remarks, pressure for dates, sexual favors, we have already discussed. If the woman is not interested and you are again and again pressurizing her for dates and sexual favors, that will be sexual harassment. Sexual or friendly remarks, unfriendly remarks, sorry. So if you are giving unfriendly remarks, sexual remarks like you are like this and something like that on her body or like appearances, then that may amount to sexual harassment. Gender based insults, that you are a woman, you can't do this project, you are a woman, you can't do this act, you can't do this work, it is not made for a woman, what are you doing here, you should sit at home. Sometimes the man says such kind of a thing at our workplaces. So that is gender based insults and tauntings, that is covered under the definition of sexual harassment. Sexually explicit telephonic calls or emails. When we were working from home during the COVID period, sometimes the people ask me that when we were working from home and we are sitting at our homes, then how we can face a sexual harassment. At that time also we can face a sexual harassment. Yes, we can, because we are in a virtual media, we are working through our phone calls, emails, WhatsApp, or a Zoom meeting or something like that. If somebody is behaving there also like that, then that may amount to a sexual harassment. Display of pornography, we have discussed. If you are having something in your laptop, in your phone, you are opening it in front of a woman or something like that, she is seeing that, making her feel uncomfortable, that may amount to sexual harassment. Now we'll discuss what will be the impact of sexual harassment. We have discussed the hostile work environment. Hostile work environment will be the something where the woman is feeling uncomfortable, insecure. And we can think, if the woman is uncomfortable and insecure at some place where she is working, definitely she will not be able to trust anybody. She will not be able to give her 100% efficiency in the work. All the time she is having back of the mind that she can again face such situations, and or mentally as well as physically, she will be having issues. And in that case, sexual harassment not only is a violation of women's rights, because she is not living her life as with same rights with the as a man, because they are freely working there, they are having the good environment, but the woman is feeling something insecure there, because that is the equal right we are having to work, to live with dignity, with are living our life, leading all the things like a man. Then in that case, if the woman is feeling having the sexual harassment, there it will be considered as violation of women's right to equality, life and liberty. And the entire goal of economic growth will be affected. And the organization's goal of inclusive growth will also be affected, because morale will be down. The women will not be able to give the 100% efficiency. So this is the impact of sexual harassment on any woman. Now we'll discuss if in any organization there is a incident of sexual harassment, then what will be at stake in that case? Their brand value will be at stake, because if the organizations are spending so much of amount on advertisement, marketing and all such things, they are creating a brand value. And after creating that brand value, if it is publicized that there is a sexual harassment incident in that organization, then in that case, definitely their brand value will be negatively affected. And apart from that, decreased morale, we have already discussed, the women who is facing sexual harassment will be having a decreased morale, and decreased efficiency of employees will be there. So that will definitely affect the work environment of the organization. So that is the second loss. Apart from that, loss of money. Loss of money, why? Because now there is a full-fledged act which is prescribing the, if there is non-compliance, then in that case there will be the fine, there will be the penalty. So definitely, if we are not complying with that law, then we will be facing the penalty and we have to pay that fine. So in that case, there is a loss of money also for the organization. So we have to make sure that we comply all the provisions of this act. This is an emerging law. This is in the emerging situations. We have to have this compliance in our organizations. And wherever we are being a consultant, where we are working, every places we have to make sure that we comply this law. Now, this is very important. The entire things we have understood that sexual harassment, what it is actually, by the examples, by the pictures, by everything we have understood. But the important thing, who will be the employee here to be covered at the organization, to file a complaint, or to whom we have to provide the sexual harassment awarenesses, that you should not do this, you should not do that, so that there will not be any kind of sexual harassment. So according to section 2G of the act, the employees include all kind of employees here, whether it is regular, temporary, ad hoc or daily wages. This is very important thing to discuss here, that in all other labor laws and in all other acts, the most of the time the regular employees and who are having the permanent status are included most of the time, because and there is a specific time period that you should be working with that organization, then only you will be covered under the definition of the employee or the worker or the something like that to whom the act is covered. But now here in this act, if you are working for a 1 day, you are voluntarily basis working without remuneration, you are working, you are either you are regular, temporary or ad hoc employee, all the employees will be covered under the definition, or either directly or through agent. If the agent is also employing, we have hired some agent to do this kind of work in our organization, he has hired somebody as further, so that some person, other person the agent has hired, that employee will also be our employee. And if without a remuneration, if we are doing something charity kind of a thing our organization is doing, and the voluntarily people are coming to us and saying that we will be working for you these 4 days, 5 days or during this project, then in that case those persons also be our employees within our organization, whether the terms of employment are express or implied. Maybe there is no contract, there is no appointment letter, and you are intern somewhere and there you are facing some kind of sexual harassment, then also you are covered under the employee definition. So you can file, if you are facing any kind of sexual harassment, you can file a complaint. So the definition of employee here is very vast under this act. Now we'll discuss the workplace. These two things are very important to understand, because you can take your rights, you can take preventive measures, prohibition measures, as well as you can file a complaint when you know that what will be the workplace, what will be the employee's definition. So that is why we are discussing this here. All premises, including corporate offices. Sometimes the organization is very big. It is having the corporate office, head office, as well as many branch offices. So all these offices will be covered under the definition of workplace. If you are visiting any branch office, there any employees has misbehaved with you or done any kind of incident of sexual harassment, there also you can file a complaint to that ICC of that branch office. So all are covered. All other premises, location, establishment, institution, unit, sites controlled directly or indirectly by the company or where the business of the company is conducted from. There, all the places will be workplaces. All other premises where the employees of the company are visiting during the course of their work hours. So there also in CA forms and sometimes in CS forms, CA forms and the lawyers, we are visiting some places where we are going to provide the services related to like audit services or some kind of thing there. So that places will be the workplaces for us because during our work hours and visiting for the official purpose we are visiting there. So we have to be protected there also. Includes the transportation and accommodation. If the company is providing transportation and accommodation to the employees, then that will also be a workplace for them. Now we'll discuss major aim of this act is why this act is framed that no women employee shall be subject to sexual harassment at workplace. This is the aim of the act. This is the preamble of this act. Now we'll discuss if any woman is facing the sexual harassment, then what they should do first. Like earlier, we have discussed earlier, we had to reach out to the police, file a complaint, FIR, then facing the court procedure and everything. That is what the reason the women are not complaining the sexual harassment incidents. But now we are having the ICC that we will discuss later on, that what is the internal complaints committee. Basically, everything is being done inside our organization and everything is in confidential manner. Nobody, in fact, the colleague sitting beside you will not be aware about it that you have filed the sexual harassment complaint if you are confidentiality maintaining the confidentiality properly in your organization. So this will be very easy process to report any kind of sexual harassment, and that is the intent of this act, that women should feel comfortable making complaints if she is facing any kind of sexual harassment. So now women can take proper action. They can be aware about their rights. They can file a complaint and they should not ignore any incident of sexual harassment in the hope that it will go away one day on, because if the man is doing, if anybody is doing to you any kind of sexual harassment, they are not going to stop until unless you are not raising your voice. So be very, very cautious about it. Speak out properly that you have faced any kind of sexual harassment and speak out about it. Speaking out about sexual harassment is an effective tool in combating it because you can stop it by speaking out only. Without reporting it, you won't be able to stop it. Be sure to say no clearly and firmly. If you are not liking something, don't feel that he is your senior or she is your senior. She is going to feel bad if you'll say no. Be sure that you always say no if you are not liking it firmly and clearly. Don't blame yourself and don't delay. We don't have to delay in filing complaints and अपने आप को blame नहीं करना है that why this happened to me, why I am the in this position. So you don't have to blame yourself. Now we'll discuss what is the duties of employer. If we are employing somebody, whether we are employer or employee somewhere, we are having some duties. That being an employer, there is a very big burden on the employer to provide the safe working environment and to comply with the provisions of this act. This is a very, very important role the employer have to face here because providing a safe working environment is the foremost requirement as per the act, and safety from persons coming into the contact at the workplaces. Whatever people are, whosoever is visiting your workplaces, you should be, the employer should make proper guidelines, proper framework that those persons also not in any way indulge into a sexual harassment incident with a woman working there. Display at conspicuous places at workplace penalties and consequences of sexual harassment. Most of the time in whatever organizations we are members, the external members, we are advising them to display at their notice boards, at the reception area, the full details of the ICC members, whatever guidelines they are following for combating the sexual harassment, for removing it from their workplaces, and having the logo that sexual harassment and cross mark that here sexual harassment we are having a zero tolerance and we are totally taking all the measures to prevent the sexual harassment. So at conspicuous places like notice boards and reception area where people are visiting every day and seeing the proper that place, that yeah, this is the measures we are taking. So this is displaying this kind of images and this kind of attempts are sexual harassment, to remove the sexual harassment from the workplaces. This will be the duty of the employer. Order constituting the committee. Employer only constitute the committee in cases of organization where more than 10 employees are being employed. There it is the duty of employer to constitute the committee, the internal complaints committee inside the organization, which is having the internal members. The internal employees will be the members of that internal complaints committee. Everything will be internal. Organize workshop and awareness programs at regular intervals. Wherever we are being members of the sexual harassment team, there we are timely providing these workshops, awareness programs to all the ICC members as well as the employees also. So this is a important thing the employer have to do, that they should make sure that organization is having the workshops and awareness programs for all its employees, that what are their rights, what are the workplace behavior they should follow, and what is the sexual harassment. They all should know. They all should be aware about it. Display on notice board of the premises giving full details of the members of ICC, so that any member, if facing sexual harassment, is going to complain to ICC members only. Providing necessary facilities to the committee for dealing with the complaints and conducting an inquiry. This is also the duty of the employer to provide the ICC all the facilities for conducting an inquiry. Assistance securing the attendance of the witness and respondent before the committee. If there is any kind of sexual harassment complaint, then this is also the duty of the employer to secure the attendance of whatever witnesses they are naming before the ICC for investigation. Now we'll discuss few important case laws. Here, in this case, Malvika Bhattacharjee versus Internal Complaints Committee, Vivekanand College and others, 2021. This case has been decided. In this case, the High Court of Calcutta clarified that sexual harassment complaints against another individual of the same gender is maintainable under the POSH Act. Why I am covering these cases? Because most of the time people are having these questions from me, that can a same gender complaint be entertained under the POSH Act? Yes. As per this case has been clarifying this issue, that yes, same gender complaints can be entertained under the POSH Act. If the woman is doing sexual harassment against a woman, then women can also file a sexual harassment complaint against that woman. So this is maintainable properly, because in the court has held that in this case, when the people can think about marrying a same-sex person, then they can have sexual harassment against the same-sex person. So that is why in the present era, when there is a question pending before the Supreme Court that same-sex marriages can be done or not, then there can be a sexual harassment against the same sex also. So complaints are maintainable. Now we'll discuss the second thing, Apparel Export Promotion Council versus A.K. Chopra. The Supreme Court in this case held that sexual harassment is a gender discrimination against a woman, and also said that any act or attempt of molestation by a superior will constitute sexual harassment. Any act of molestation, like you are going beyond your powers and unnecessarily harassing a woman, then in that case, that kind of molestation and gender discrimination, you are, despite the woman is properly compatible to do the particular thing, you are preferring the man only to that case, that kind of discrimination also amounts to a sexual harassment. This has been decided by the Supreme Court in this case. Mrs. Rupam Deol Bajaj versus Kanwar Pal Singh. This case has changed the meaning of the word modesty and privacy in such a way that any kind of inconvenience done to a woman's personal or public life will be considered as an offense under this act. Sanjeev Mishra versus Disciplinary Authority and General Manager. The court held that in the present era of digital workspace, when employees are working in different branches of the same organization, it should be treated as one workplace. Workplace definition we have seen. So there, if they were in different departments, if the people are working in the digital workspace, even if there is a same organization and people are working in different departments, then also they are working at the same workplace. Bhuvan Chandra Pandey versus Union of India. The court in this case held that the sole testimony of the victim is sufficient in the cases of sexual harassment unless there is a reason to question it. This is very important case. I'll elaborate this little bit. in this case, it has been sometimes there is the man and the woman only. Nobody, no evidences, no witness, no camera, nothing is present there. So in that case, if the woman is alleging the sexual harassment and there is no evidence or no witness, there the sole testimony of a woman can be treated as a evidence for deciding the sexual harassment complaint. And there is, unless there is a reason to question it. If the woman is giving a contradicting statement, suppose in complaint she has written something as, but in evidence she is saying something as, and the witness she has called, he is also saying, he or she is also saying something as. So if the contradicting statements will be there, then there is a reason to question it. Then it can be questioned. Otherwise, sole testimony of a woman can be a reason to decide the sexual harassment complaint, to give a report on sexual harassment complaint. There is always no need of documentation and evidences. Ruchika Kedia versus Internal Complaints, Goa Institute of Management, through its President Professor Anamika Sinha and others, 2020. In this case, the Bombay High Court set aside the report of the ICC. We will discuss here in the later part of the this webinar that ICC has to give report only. ICC is not having the, in the Internal Complaints Committee is only can investigate the complaint. They cannot take any action. The employer have to take an action. So if you are not satisfied by the ICC report, you can challenge that in a court. In this case, ICC report, whatever the report is given in the ICC after the investigation of the complaint, it has been challenged in the High Court. And after that, it has been challenged. The High Court has set aside the report. Why it has set aside a report? The reason being, as it was observed that the external member of the ICC was not a member of any non-government organization or association committed to the cause of women or a person familiar with the issue relating to a sexual harassment. So in this case, it has been held that if the ICC is not properly constituted, whatever requirements prescribed in law, like one person, the presiding officer should be the senior most member, and the two other members should be the person who are dealing with the related to crime against women, work for the NGO. They are aware about the, sensitized about the women related laws. So if those kind of persons, and one person should be the external member who shall be from the non-government organization having the proper dealing with such kind of cases. So if the constitution of ICC is not valid and that ICC has investigated the complaint and given a report, then that can be on the basis of ICC being totally not constituted properly. On the basis of that, that report can be set aside, and in this case that has been done. So this, we, after this case, we will understand what is ICC properly, because its proper constitution is very much required. If the constitution of ICC is not proper, then that ICC report, investigation done by that ICC, then all can be set aside by the courts. Complaints committee. There are two types of complaint committee. We'll discuss. ICC is a internal complaints committee. LCC is a local complaints committee. The ICC is basically the internal complaint committee inside the organization. LCC is basically the local complaints committee, which is dealing with the outside, like if the woman is not, like if suppose the organization is having less than 10 members, 10 employees, in that case the district officer, basically the DM of the concerned district, have to form the local complaints committee, that is the LCC, and that will be having the members which will be dealing with the like block person, tehsildar, or the woman dealing therein. That kind of persons will be involved in the LCC. This is for organization where less than 10 employees are employed, and ICC is for organization where more than 10 employees are employed. So that organization will have internal complaints committee from inside their members and one external member. Now we'll discuss Act provides two kind of complaint mechanisms: internal complaints committee and local complaints committee, that we have discussed with. Now constitution of ICC will discuss, where the employees are more than 10 and the company itself inside its organization is constituting the ICC, internal complaints committee. There one should be the presiding officer, and that will be the senior level woman of employed in the organization from amongst all the employees. Two members, and those two members will be amongst employees preferably committed to the cause of women, or who have had experience in social work or have legal knowledge. So that can be the legal head of the organization and the HR head who is more aware and work for the cause of the women. That can be the members basically. So external members from an NGO or an association committed to the cause of women or persons familiar with the issues relating to the sexual harassment. So that external member should be possessing this quality. You cannot appoint any external member like she's an advocate, he's an advocate. That should be a member from NGO, an association, so who is dealing with such kind of cases. So if the constitution of ICC is not as per this requirement, then in that case, that ICC report, that ICC investigation can be set aside by the court, as we have seen in the example. And there should be, while constituting the ICC, the employer shall keep in mind that at least half of the ICC members should be the women, and the term of the ICC should be at least 3 years, and it shall not exceed beyond 3 years. So a minimum of 3 members of the ICC, including the presiding officer, are to be present for conducting the inquiry. If there is a 4 member, because one is the presiding officer, 2 is a member, and the external member. 4 members ICC is there. At least 3 should be present in the any investigation of any complaint. Then only it can be carried out. If 3 members are not present, then it cannot be carried out. So most of the cases there can be a 5, at least 4 members. These 4 members should be there, but companies may have 5, 6 members in the ICC. Most of the time they are having, if extra members they want to have, but these 4 members should be present. Now we'll discuss LCC. District officer will constitute the LCC in every district. Apart from this, one more thing we'll discuss. If we have discussed that companies having more than 10 employees will have to constitute ICC. But if the companies are having a register office, branch office, and the many administrative office and units, there at all such places, different ICCs should be formed. This has to be one in mind. And LCC district officer will constitute, and who will be the member of this LCC? We will discuss. Eminent chairperson. We have discussed the presiding officer in ICC case. Here will be the chairperson, an eminent woman in the field of social work and committed to the cause of women. That will be the chairperson. 2 members working in a non-government organization or association committed to the cause of women, or a person familiar with the issues relating to sexual harassment. One of them should be a woman. This will be the 2 members. Member, a woman working in a block, taluka or tehsil or ward of municipality in the district. These all shall constitute the LCC. LCC, Local Complaints Committee, to whom those persons will file a complaint where the organization is having less than 10 workers or the employees. That is mostly in the case of housekeeping staff and such kind of like house helps, housekeeping staff. They are having something less than 10 people in their organization. For them, they have to file a complaint to the LCC. One of member who is nominated will have strong background in law and legal knowledge. Additionally, one of the member will be a woman belonging to the scheduled caste or the scheduled tribe, other backward classes or minority community. In addition to these, the officers dealing with the social welfare of women and child development in the district will be an LCC member by default. Apart from these members, they will also be the LCC member, like Human Rights Commission, Women Commission, and Women and Child Development Authorities. The senior member of their officers will also be the LCC members. Now we'll discuss role of ICC. We have already discussed that ICC will be the internal complaint committee where the woman can approach confidentiality, with maintaining the confidentiality, and she has to not to face any kind of harassment. So the first work of the ICC is to conduct the inquiry into the complaints of sexual harassment, to make recommendation to the board of directors of the company in the matters of sexual harassment after the conclusion of inquiry. They have to make only recommendation. They cannot take any action on the basis of inquiry. To file annual report as per the provisions of the act. This is very important thing. In the POSH Act also, there is a provision of annual report, because like in the case of companies, we file an annual return, and CAs also file an annual return, audit report, all such things. Like that only, this as per this act, there is a provision of filing an annual report as per the provisions of this act. Now we'll discuss. For 5 minutes, we will take some questions. Then we'll move forward to the redressal part of the meet. Yes. Anybody as of now having questions? Anybody having question, they can raise their hands. Otherwise, we will move forward for the other part of the redressal part of the.
Yes, ma'am. Hello. Ma'am, my name is Yogesh, and I'm working as an advocate. So
your voice is not properly audible. Please be a little loud.
Yes, ma'am. Yes. Now I'm audible. Now I'm audible.
Yes, yes, but little bit please louder because there is some issue in your mic.
Okay.
Yes, yes.
So,
Tell me
so
now
my
you are audible.
yeah. So my question to you is whether
Yes.
whether a victim who is the victim of the sexual harassment in the office, so in the spite of going to the ICC, whether she can file a complaint in a police station or. Hello.
Your voice is interrupting. I'm so sorry. I could not hear your question properly. Anybody else? You can please fix your mic. Then you can ask a question. Anybody
Sure.
else? Anybody else wants to ask any question? Shall everything is clear to everybody? Then shall we move forward? Anybody at this moment? Nobody is having question.
I do have a question, please.
Yes.
Is there any provision with respect to men when they are being harassed by some women or by men at workplace?
Yes, yes. This is very important question. Most of the time, when we are taking sessions and we are in the companies, most of the mans ask this question. So this is very good question. I'm going to answer here. As there is a provision of having the POSH policy also in the sexual harassment this act. So most of the time we ask the companies to frame a POSH policy which is gender neutral for both the man and the woman. This act is particularly we are discussing today for a woman only. I cannot say that this is for man also and the women, but the POSH policies we are making in the companies in our guidance, that POSH policies for the men's and the women's both, and whatever procedure of filing complaints and dealing with the sexual harassment things we are having for the men's also in all our companies, and that POSH policy is prescribing the same procedure, same kind of things for a woman and a man. So there they can approach to the ICC. They can also file their complaint as per ICC if he is being harassed by any woman, senior woman employee or the colleague. They can also file a complaint. They can also get it because there is no bar. This act is about the women. That is okay, but there is no bar if we are having the same kind of procedure, same kind of policies for a man also for dealing with the complaint, the all kind of behaviors we are having for maintaining the security of a woman, we are also having for man also. So this act is not prohibiting that, but this is exclusively for a woman. I think your question is answered properly. Is it? Anybody else?
Thank you, and thank you for the clarification.
So let's move to the other part, redressal part of the. I'll take 10 to 15 minutes more for the redressal part of the complaints under the POSH Act. Now we'll discuss procedure of filing complaints under the POSH Act. How to file a complaint. This is very important thing. We have understood who will be the employee who can file a complaint, who will be having the right to file a complaint under this act, and what will be the workplace inside which they will be covered under this act. So this will be the next step, that if despite taking the preventive measures, despite making our employees aware, taking all steps to prohibit it in our organization, despite there is any such sexual harassment incident happens in our organization, then how the employees can file a complaint. This is very important for them to know. So this complaint has to be filed in 6 copies. That can be via, because most of the time ICC members, whosoever is the ICC members, these 2 members, first presiding member and the external member, their contact details, their email IDs, everything is placed on the notice board and the reception area of the companies, so that everybody can see that. And if they are facing any kind of sexual harassment, they can reach out to them by emailing the complaint, by directly going to them and give a written complaint. That complaint should be a written complaint. This is very important to know. You cannot go directly and say orally that this is the complaint I'm having against that person. So you have to make it in writing. If you are having any evidences of that sexual harassment incident, then you have to annex that evidences with your complaint and file it to the any member of the ICC you can approach. Preferably with the ICC presiding officer you can approach, or the members or the external member. You can approach to any of them to file your complaint in writing, and that should be in 6 copies. Apart from that, you have to mention in your complaint clearly the name of a person, the place where it has happened, the address of witnesses has happened. Is there a timeline which a complaint has to be filed? Yes, this is very important. For complying any law, for making any complaint, the law always provides for a time after which you waive off your rights, after which you cannot file that complaint. So this time is 3 months from the date of incident of sexual harassment. And in cases where the incident of sexual harassment happened again and again, once, twice, or 3 times, then in that case, from the last date of incident, you have to file a complaint within 3 months. And in exceptional cases, if the woman is having the mental issues, physical issues, or that the incident was so brutal that she is not in a position to file a complaint for 3 months, then in that case, in such exceptional cases, we can grant the extension of 3 more months. We can continue the delay, and 3 more months she is having for filing a complaint on showing the sufficient reason for the same. So this 3 plus 3 extended 3 months. Apart from this time period, there is no further time period will be granted to file a complaint. So we have discussed how to file a complaint and what will be the time limit of filing a complaint. Next, we will see who can file a complaint. Any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal complaints committee, if so constituted, or to the local complaints committee. In cases where less than 10, to the local complaints committee. In cases when the internal complaint committee is there for more than 10 employees, companies, there they can file to the internal complaints committee. But who will file? The aggrieved woman, her legal heirs. If in case the woman is not alive, woman is unable to make a complaint on account of her physical or mental incapacity or death or otherwise, her legal heirs can file a complaint, or such other person as may prescribe may make a complaint on her behalf. Like if somebody was present who has seen the incident happening with that woman who is not alive now, so that person with the consent of her legal heirs can file a complaint of sexual harassment. So these persons can file a complaint now. Now we'll discuss if the complaint of sexual harassment received. First of all, what we can do. We don't have to approach directly for the investigation. We have to, first of all, we have to, if the woman is requesting, that complaint is of a small kind of thing, like it can be settled at first instance. Then if the woman is approaching to you who has complained of, then you can consider the conciliation procedure first. If they, but we cannot force a woman to opt for a conciliation procedure. We cannot say that. The woman has to approach us that yes, my complaint is short and my complaint is of some little bit issue, then we can get it reconciled, we can get it solved in the conciliation procedure. Then in that case, we first of all call both the parties, let them sit, and if they are agree at some point, then considering that point, right, making it in writing, we can resolve their complaint at that place only in a conciliation. Like we have all advocates or a CS all persons, then we can know that mediation procedure, like that kind of procedure we can follow here. We can get their grievances resolved there, make it in writing and get it solved. But this is very important thing. The ICC should not suggest a compromise between the parties on the basis of monetary terms. First of all, we will not suggest a compromise. We will not call both of them voluntarily for compromise. We have to make investigation if the woman is not paying for conciliation. She is not ready to settlement. And this settlement should not be a monetary settlement. By this, the act has prohibited monetary settlement because women will file the false complaints and they will ask for the amount, and after taking the amount, they will resolve their complaint. So in that case, to resolve this issue, to curb out that problem, the monetary settlement has been specifically prohibited. There will not be any monetary settlement and no amounts will be provided. If that kind of settlement comes, like if the man is being transferred to the other department, he will not be reporting to, she will not be reporting to her, that kind of terms if implied, and the woman is okay with that, then it can be settled at that position. And once the settlement is recorded and the copies of the same are provided to the parties, the ICC does not have to proceed with the inquiry. In such case, we will not proceed with the inquiry. We will settle this matter here, make out the settlement in writing and send it to the employer and give both the complainant and the accused person one copies of the settlement and resolve this issue at this point only. And if the woman is not approaching us for the settlement, then in that case, the inquiry will happen. And in case of inquiry, the same procedure, the ICC will follow the same procedure of inquiry provided in the CPC, like, and they having the same power of the civil court for calling the witnesses, for production of documents, for production of evidences, all such powers the ICC will be having. The ICC is also entitled to give ex parte decisions. If despite notice, first of all, the complaint is received, the notice will be sent to the accused person that this is the allegation against you, please file your reply within time. And if he fails to appear, or if the after making the complaint, if the woman fails to appear for 3 days at least, which is a notice 15 days in advance, we are intimating them that we will be having the hearing at least after 15 days. And after giving the notice also, they are not appearing. Either the accused person or the complainant is not appearing. Then in that case, where the complainant or the respondent fails to present their case, appear before the ICC upon being summoned without sufficient cause for 3 consecutive hearings, despite giving 15 days notice in advance, then the ICC can give decision in ex parte decision, and they can decide the complaint either against the complainant or the other accused person or the respondent who is appearing. Such inquiry must be completed within 90 days. This is very important thing to understand, that inquiry has to be completed within 90 days. There is a time frame. Once you receive the complaint, if there is no conciliation, then from the receiving the complaint, there is a period of 3 months, 90 days you are having to complete the inquiry, to record the evidences, to take the reply, and to hear out both the parties, and after that giving your recommendation, your inquiry report. You are having 90 days for concluding all such things. Submission of ICC report. Post the completion of inquiry, the ICC will have to submit a report with its conclusion from the inquiry to the employer within 10 days of completion. Within 90 days, this inquiry has to be completed. After 10 days from this 90 days, we have to conclude, we have to submit this inquiry report to the employer. And the ICC report should be the final report. It should not be illusionary, that it should either say that sexual harassment has happened or not happened. That it has to mention. And if the sexual harassment has happened, then in that case, what will be the recommendation of the ICC? They have to mention. If the ICC concludes that sexual harassment has taken place, it should recommend to the employer to take necessary action against the respondent as per the service rules. If there is no service rule, then that can be as per the Rule 9, which includes written apology, warning, withholding promotion, increments, termination. This can be the recommendation made by the ICC to the employer, that this can be the actions taken against this person who has committed sexual harassment. And the employer has to take this into the notice and take decision appropriately within next 60 days. Such action by the employer must be taken within 16 days of receipt of the recommendation by the ICC. Employer cannot be sitting like once he has received the recommendation, despite that he is sitting beyond 60 days without taking any action. That cannot be possible. If that happens, then the woman can approach to a court that he has not taken a action within 60 days on the basis of inquiry report, despite an inquiry report. The ICC can also recommend a deduction of salary of the respondent, any amount as may be necessary for the payment of the compensation. If this act is also providing for payment of compensation, if it is found that the sexual harassment incident has happened with the woman by the accused person, then they can also recommend to deduct the amount from the salary of the accused person, or the from the salary of the person who is found guilty of sexual harassment, for paying to the complainant. We have already discussed the inquiry report should be full and final. It should specifically mention whether sexual harassment has happened or not happened. During the inquiry, it is termed out or not. the ICC should take steps to ensure that the complainant and the respondent. This is very important thing. 90 days time period is there where the ICC finds ICC has to inquire the complaint. During 90 days, what will happen to a woman who has faced the sexual harassment or a man? Can they work properly in the same environment? No. In that case, if the woman is approaching and saying to change her department, to give her work from home, or to suggest any measures which is comfortable for her to work during that time period, then we have to, the ICC, that means ICC have to take steps to ensure that the complainant and the respondent do not make contact to prevent any further harassment to a woman. Potential harassment threat should be identified. What kind of harassment she can face? We have to identify that, being an ICC member, at the beginning itself, to suggest preventive measures to the employer. What kind of preventive measures that can be? The ICC, on the written request of the complainant, can direct the organization to restrain the respondent from reporting or reviewing the complainant's performance or writing any confidential report pertaining to her. If that person against whom sexual harassment has been alleged, that person is the superior or senior who to whom she is reporting, that person cannot be allowed to write a performance report about that lady or a woman. He cannot give confidential report about her. That ICC can make sure. The ICC can also recommend the employer to transfer the complainant to another workplace. That she can be transferred to other department where she can work, or to some other branch office or some other place during the pendency of inquiry. Grant her leave up to 3 months or any such relief as required to safeguard her from further sexual harassment. The report of such action during the pendency of the inquiry must be sent to the ICC. Whatever action has been taken by the employer, that report has to be sent to the ICC, that this action we have taken to safeguard the woman, and they should know about it. Now, this is very important thing, that confidentiality have to be maintained in the POSH complaints. If the ICC members have received any complaint, they don't have to discuss it with any other person of the organization. And the woman also who's facing the such kind of sexual harassment, if she is discussing it with somebody else, that person should be directing her to the ICC only, saying that this is very confidential thing. You should directly approach the ICC. Don't discuss it with anybody else. So this is confidentiality. Why this is maintained? So that women and the man who is being accused, that they can be having the better workplace environment and not being spread in the entire organization. That is why, for safeguarding them from harassment or some kind of embarrassment, this is confidentiality being maintained. And this confidentiality provision is there, and apart from this is outside the purview of the Right to Information Act. Nobody can seek information about any complaint, any proceeding, any inquiry done in the sexual harassment complaints from anybody, from any organization. We cannot ask any information under the Right to Information Act. This is beyond the purview of that Right to Information. And prohibition on publication. ICC or the committee or the employer or anybody cannot say anything to the media, to the any other person outsider or inside the organization who is not having nothing to do with the complaint. If he has to come for the evidence, then he will know about the complaint and every such thing. That witnesses, the complainant and the respondent or the accused and the ICC. It should be between them only. It will not be publicized. It will not be told to the media. Yes, if the woman is secured the justice, if it has turned out to be that yes, the person has guilty of sexual harassment, and whatever measures has been taken to safeguard the woman, that can be only elaborated, that we have resolved the grievances and we have find out that this has happened. But who has done that, who was the complainant, the entire names and everything should not be disclosed to anybody. And this is, we have already discussed, outside the purview of Right to Information Act. Nobody can seek such information from any organization. The last part we will discuss, punishment and complaints for false evidences. We have seen in the recent trends, that there are very much cases which are malicious and false complaints being filed by the women sometimes against a man for sexual harassment, for rape, or for some kind of a thing. So that is why courts are taking it very seriously, and there is a provision for imposing cost. They are sometimes, companies are sometimes firing such employees who are filing the false complaints. So these are the provisions for false complaints also. The bans are also being safeguarded. If an employee is found to have raised a malicious or false complaint or given any false evidence, such complainant or such person making evidence may also be subject to appropriate disciplinary action. What can be the disciplinary action? That can be as per the policy of the company for its employees, which may include termination of employment, de-engagement of relationship with the company, or as the case may be. This kind of things can be done for filing false complaint. You can be terminated from your job. Now this is the important case, which is for filing a malicious and false complaint. Anita Suresh versus Union of India and others. The Honorable High Court of Delhi has found the writ petition without any merit and dismissed the petition with cost of rupees 50,000. 50,000 cost was imposed on a woman only to file for filing a false complaint to be paid by the petitioner, and also found that an appropriate action may be initiated against petitioner for filing false complaint of sexual harassment. The court has also suggested the person on whom the allegation has been imposed in this case that he can also file a complaint of defamation or such kind of a thing on a woman if he has if she has filed a false complaint on him and without any merits. Now this final portion we are annual report. What is this annual report under the POSH Act? District officer, we have seen mostly it is a DM of the concerned district. So annual report has to be filed in every calendar year to the district officer, which contains the following information: number of cases filed, if any, if the ICC has received any sexual harassment complaint, that has to be mentioned in the annual report. Their disposal under this act, that how much of cases we have disposed and what recommendation we have made to the employer. This will be mentioned. It is the duty of the ICC of the organization to timely file the annual report of the district officer concerned. This is the ICC's duty, that they have to ensure that annual report is being filed within time. Mostly this calendar year means 31st December. So 31st December, we mostly file by 30th January of every succeeding calendar year. Now we'll discuss district officer is very performing major role in this act. He is monitoring the timely submission of the annual report. So you cannot be lenient that if we will not file, what will happen? Because district officers are very much serious about it. They are properly responding to the reports that they have received it. If there is any thing missed in the report, they raise an objection that this thing you have not mentioned when the session has been conducted, how much complaints you have received, what recommendation you have made, you have not properly mentioned. They properly raising the objection, they are properly responding to that. So this is very important. They are monitoring our filing of annual report. So we have to file it within time. Take such measures as may be necessary for engaging NGO for creation of awareness on sexual harassment and the rights of women. Mostly the companies are inside having their own organizations to carrying the awareness programs, workshops and NGOs. But to those small organizations where less than 10 people are working, for that portion of the organization, district officers are getting the awareness programs done by hiring the NGOs. Now the last part of the penalties we were discussing, that why we have to comply this act now very seriously, because there is a penalty, there is a fine prescribed under the act. That is why organizations are being serious and they are taking it seriously for compliances. So where the employer fails to constitute the internal committee or take action, if the employer has not taken as per the recommendation of the ICC, then not taken action within 60 days as per the recommendation of ICC, or not constituted the internal complaints committee. In such cases, employer has to face the fine of rupees 50,000 if there is a first contravention, and if there is a subsequent contravention, then it can be double the first fine. So it can be twice of the fine. So this is the penalty prescribed. Now we will all be here to know about the sexual harassment, because say no to the sexual harassment. Why we are saying? Because for making our workplace now, women and man both are joining their hands, and at the home as well as at workplaces, they are working equally, and they all are coming out to be with having equal compatibility. So being equal, having the equal compatibility, we can work together only if we are having the workplaces safer for and happier for man as the woman. So we will have to contribute towards that, and let's join the hands and make this workplaces wherever we are working safer for all women as well as for all colleagues whosoever is working together. So this is the aim of having this workshop today, or having this webinar today. Thank you very much. Any questions? Already we have taken 10-15 minutes late because due to technical issue, 5 minutes we started late. Yes, anybody having questions after this? I have discussed case laws also, so that if any question arising in your minds, you can have the legal provision for that. Apart from that, if despite that anybody having question, we can take it further.
Yes, I have.
Yes, please.
Yeah, if in case like girls will face any harassment through the like any main, but she didn't have any like eyewitness or any document or any proof, so it will be count under harassment.
Yes, obviously. It will be counted in a harassment. I have discussed one case also, that sole testimony of the victim who is filing a complaint of sexual harassment. That sole testimony can be the evidence, and that can be treated for giving a inquiry report. Because until unless the woman is not saying two contradicting things, that if she is saying something as in the complaint and she is saying something different in the evidence happening there, so if she is making the same statement and that is the sounds, there is no reason for questioning her statement, then in that case her testimony only, her saying in the complaint only can be treated as a evidence, and she can file a complaint on the basis of that and get the inquiry report on the basis of that only. There is no always necessity of evidences, because sometimes it is between you and that harasser only. Nobody was present there, no camera was there, no WhatsApp chat, no emails, nothing like of documentary proof is there. So that incident also will amount to a sexual harassment is happening in private. So that will be covered in the sexual harassment. Hope this is your question properly clear.
Yeah, thank you.
Thank you. Anybody else?
Yeah, one more thing.
Yes,
Like
please.
same thing, like girls facing any like harassment through the men, but sometimes like she is not feel like comfortable, like might be that person it will be like in high position, so
Yes.
sometimes girl will be like scared, like it will be shared with another or like no. So in that situation, name will be shared, like who raised the harassment complaints against the person.
Yes, this is very important. We have discussed how to file a complaint. We have discussed. So you have to, whether that person is the vice president, the CEO, if they are the employer. In that case, that such high person that he is himself an employer. In that case, this is very important. In the session, it is missed out. I am just informing you here that if the employer himself is involved in the sexual harassment, in that case, what will happen? The LCC, the local complaints committee framed for the particular district by the district officer, by the DM, that complaint committee will handle that complaint, because nobody is upper than that person who is himself an employer, who will handle his complaint. Internal complaints committee definitely is being his employees, they can be biased about him. So the local complaints committee formed by the district officer, he will handle that complaint which is related to the employer himself. So if apart from that, apart from employer, if whatsoever the position is of the person, that you have to mention the name of the person and you have to file a complaint to the ICC, and that presiding officer will definitely unbiasedly treat that. You have to mention the name, whether it is the employer himself, whether it is the vice president, CEO, VP, whosoever the person is. You have to mention the name, because until unless you will not mention the name, how the person, whether it is local complaints committee or the internal complaints committee, how they are going to take action, how they can summon them. You have to mention in filing any case, it is like a case. In filing any case, you have to name the second party. Otherwise, nothing, no steps can be taken, no summons can be sent to him, calling him. Understand?
Yeah, thank you.
Thank you. Anyone else? Akansha, Shalja, any questions?
Hi, Juhi. It was a very wonderful session. So I don't think
Most
there
of
is
the
any
time
question.
you are having the questions relating to the POSH, so that is why I'm asking if you are
Yes,
specifically
but it
having.
was a very wonderful session. This was my first
Okay.
time joining this POSH session. So it was
Okay,
very
okay.
wonderful and informative, very detailed.
Thank
Very
you.
good
Thank
work.
you. Akansha, you are also, I think, first time joining the session. You are having any questions or all cleared? So I think nobody is having question now. Everything is whether I am the good presenter or I have mentioned everything properly, or somebody is hesitating here to answer, to taking the answer of the question. So they can write out to me. They can mention to the Nitya sir or to write to me. If somebody is having hesitation asking here, I'll respond to their questions there. Okay. So shall we leave the meeting? Okay, thank you, everybody.
Thanks, Juhi. Thanks.
Thank you.
Thank you, Joey, for the wonderful